Okay, it's now about 2 minutes after 1, so we're going to go ahead and get started. Thank you for joining us for our webinar, Alternative Residence and Citizenship, Where, Why, and How, presented by Saul Ewing and Henley Partners. My name is Eric Orlinsky. I'm a partner in the Baltimore office of Saul Ewing. Before we get started today, I just want to note that Judi Galst and I have been talking about this presentation since last fall. And when we first started talking about this subject prior to the election last year, Judi had explained to me that she had about an equal number of clients and potential clients who were inquiring from both sides of the political spectrum about this subject. I say this initially to make the point that neither Henley nor Saul Ewing is in any way, by putting on this program, espousing any political position. We're only here to provide information to our clients and potential clients on this subject, which, as Judi will explain, is of rapidly increasing interest. I'm sure Judi will talk a little bit more about that during her presentation. Today, our presenters will discuss strategies for Americans to obtain alternative residence and citizenship through ancestry and investment, focusing on popular global programs and to highlight just some of the tax and estate planning implications of alternative residence and citizenship, particularly if one becomes a tax resident of a foreign jurisdiction. Let me now introduce our panelists. We're fortunate to co-host today's program with our strategic partner, Henley Partners, and to be joined today by Judi Galst, managing partner of private clients from their team. I'm also joined by my Saul Ewing clients, Jeryll Cohen, who is a partner and co-chair of Saul Ewing's Trusts and Estates practice, based out of our Los Angeles, California office, and David Shapiro, who's a partner and chair of Saul Ewing's Tax and Employee Benefits Group. Before we dive into the substance of our program, I need to first go over a few housekeeping items. Q&A. Questions can be submitted through the Q&A tool at the bottom of your screen. While we will do our best to answer all the questions submitted during the course of the webinar, should we run out of time, we will follow up individually by email. Webinar recordings and handouts. In the next few days, you'll receive a follow-up email that will include links to the webinar recording and supplemental presentation materials and contact information. So the entire program will be recorded and you can access the video in the future. Legal disclaimer. We're lawyers, of course, so what would we be without a legal disclaimer? The provision and receipt of the information in this program, A, is not legal advice, B, does not create a lawyer-client relationship, and C, should not be acted on without seeking professional counsel who have been informed of the specific facts in each individual case. And with that, I'll turn it over to Judi, and we can bring up the slides and begin.
Thank you so much, Eric. I'm really delighted to be here today and to introduce everybody to the world of investment migration. Next slide. For those of you that are not familiar with Henley Partners, let me first start by introducing myself and telling you a little bit about what I do. As Eric said, I'm managing director of private clients, and I kind of wear two hats. The first is I work directly with clients, trying to understand what their goals and objectives are, and then make recommendations to them on a strategy of a program or perhaps more than one program that might help them get to their end result. I also work very closely with intermediaries like Saul Ewing, which is a great partner of ours, as an extension of their advisory services so that their clients that have questions about investment migration have a trusted advisor that can assist them. Henley Partners has been in this business for over 25 years. We actually are not lawyers, we're advisors. We have 60 offices around the world, and we specialize in helping people get alternative residence, alternative citizenship, by investment. We also can help people that will qualify by descent. And we have a government advisory line of business. So over the next 20 minutes, I'm going to start to talk about different programs. Many of them have actually been created by Henley. We provide strategic consulting, design, setup, and operation of many of these programs around the world. To date, we've raised over $15 billion in foreign direct investment for countries that have them. Next. So you might be wondering, what is investment migration? There are about 100 countries around the world that have laws that say if an individual or a family makes some sort of financial investment in the country in turn will grant them the right for residency or citizenship. And it's not just poorer nations that have these programs, although they did start originally in the Caribbean. St. Kitts was the first country about 30 years ago that implemented a program. They tried to figure out what can we do to generate money to help us pay down debts and invest in infrastructure. And they decided that a strategy would be to offer a route for citizenship in exchange for some sort of financial contribution. But today, about 90% of the programs are in high income countries. And it may be surprising to some of you today to know that even the United States has a program that allows one to gain a green card with a path to citizenship by making an investment. Around 60 jurisdictions actively promote programs, but there are 30 of them that are the biggest share of applicants. All 26 European Union member states have a program that will allow one to get residency by making some form of investment, and all 19 sovereign countries in the G20 offer a mechanism to encourage inward investment in exchange for residency rights. Next. So you heard me mention alternative residence and alternative citizenship. And I want to explain the difference between residence and citizenship. This is one of the first things I do when I sit down and I consult with a client. It doesn't make one necessarily better than the other, but they do provide different value. And so it's important to understand it. It can definitely guide the conversation. So first, residence does not mean the ability to have a house somewhere. Residence means the ability to live in a country unlimited. So the US passport is very strong. We can go into other countries, many cases without any kind of visa, but we can't stay there forever. For example, we can go into Europe for 90 days, and then we must leave for 90 days before we can re-enter for 90 days. So if you were to get a residence in a country in Europe, you would be able to avoid that 90, 180-day rule. You would be able to live there 12 months a year. And there are several programs in Europe that have residence programs that will allow you to do that. Usually a residence program is going to come with some form of conditions to maintain it. So if you get a residence by making an investment, for example, Greek residency, invest 250,000 euros in real estate. If you sell that real estate, you will not be able to renew your residence permit. If you pursue the Portugal Golden Visa, once it's granted, you must visit Portugal 14 days every 2 years. If you do not check that box, you will not be able to renew your Portugal Golden Visa. They also are not permanent. So when you gain a residence, you will have to renew it unless there is a route to permanent residency, which often can be part of the process. You could get some travel rights. This is usually not as relevant to someone with a US passport because we have a really strong passport. But for example, if you were to get a residence from a country in the Schengen area, which are the borderless countries within Europe, 29 countries, you gain access to all the Schengen countries. So for someone that has a weaker passport, say from South Africa or from the Philippines, and they need to get a Schengen visa every time they travel to Europe, it can be a strategy for them to get a residence in Europe to gain that improved mobility. And it may have a path to citizenship. Citizenship, on the other hand, is different because it's a lifelong right. Once you are granted citizenship to a country, it's very difficult for them to take it away from you. It often can be passed down to future generations. When you are granted citizenship, you gain the right to a passport, and with a passport comes international travel rights. Now, the strength of the passport will dictate how great those international travel rights are. But for example, the Caribbean passports are quite strong right now. So by gaining a Caribbean passport, you can gain visa-free access into over 150 countries. You will gain access to country benefits such as healthcare and education. In some cases, you can get those in a residence permit as well, but they may not always be extended to you. And it provides you the ability to live and work and study in the country of citizenship. But where it's incredibly powerful is if you become a citizen of a country in Europe that's a member of the European Union, because as a citizen of one country in the EU, you gain the right to live and work and study in any country in the European Union. Next slide. So you may be wondering who does this? And if you asked me this question 4 or 5 years ago, my answer would have been very different. As I said, Henley Partners has been in business for 25 years, but historically we were not supporting many American clients. Most of our clients were from emerging markets. They were from countries that had weak passports. As I indicated earlier, this can be a vehicle to help someone improve their mobility. If they have a weak passport, always having to get visas to go into other countries, they get a passport for another country or residence that's going to grant them entry into other countries without having to get a visa. They often came from countries where there was political instability, they lacked access to sophisticated banking systems, they didn't have access to good education or health care. They were more inclined to relocate to create a better life for their families. They often didn't come from countries that tax on worldwide wealth like the US. So this could have been a strategy for them to establish an alternative tax residency. And that was the bulk of the clients that Henley supported. And then in 2020, things changed. Next slide. The first surge from developed countries, and specifically the United States, really came in the pandemic because if you remember, many countries blocked people from entering with a US passport because we had so much COVID here. And that was really like the first time I think people started to think like, ugh, like this could happen to us. I have this vacation house. I can work remotely. I would like to go, be at my vacation house in the Caribbean, but they couldn't get there because their passports were blocked. They had private planes. They couldn't land them. And so they started to explore, like, maybe I should, to mitigate risk, have an alternative mobility option. And at this point, Henley didn't even have offices in the United States. We were servicing all this business out of Canada. And I think they thought as a firm that this business and interest from the US was going to die down. But it has not died down. It actually is exploding in terms of interest coming from Americans right now. We now have more American clients than any single nationality. And just to share a couple statistics with you to demonstrate what we're seeing is if you compare first quarter 2024 to first quarter 2025 in inquiries that we are getting from the United States, there's a 138% increase. There was definitely a spike after the election, but despite that spike, first quarter 2025 is still 29% higher than fourth quarter 2024. So this is a sustained increase in interest. And if you were to go back to like 2019 and compare the kind of inquiries and business that we're getting from Americans, there's a 1,000% increase. Next slide. So I alluded a little bit to some of the drivers and what's making people want to explore having an alternative residence or citizenship. I want to elaborate a little bit. So the first, of course, is freedom of movement. I gave the example of COVID-19, where people sort of understood the risk of having one passport, but it's not all doom and gloom. I talked to plenty of clients that are planning for their retirement and they want to spend more time in other parts of the world. They want to buy a house in France, perhaps, and spend 4 or 5 months in a row there, which they can't do consecutively. So we need to come up with a strategy so that they can realize that. I talk to people who have established alternative tax residency, say in Florida, but they don't want to be there for the summer months. So they might get residence rights in Italy and spend 4 months, 5 months in Italy during the summer. We have a lot of clients from the UK that with Brexit, they lost EU access. So they're looking for ways to sort of be able to spend more time in Europe that they don't have a right to because of Brexit. 90% of the calls that I have today, there is some reference of a plan B. People are feeling unsettled today, and they view this as an insurance policy. They pay a lot of money for insurance for other things. They insure their house for fire, and they don't think it's going to burn down. And similarly, they want to have options that if something were to happen in the United States and they felt that for some period of time they wanted to leave, they want to know they have a guaranteed right to be able to do it. Some are thinking in terms of wealth and mobility preservation, creating opportunities for future generations. They may feel like, yes, things are a little settled now. I think it's going to be fine in my generation, but I'm thinking about my kids. I'm thinking about my grandchildren. Yes, I could leave them $10 million when I die, but I'll leave them a little less and I'll make sure that they have an EU passport. Some are thinking about expanding businesses internationally and know that by having alternative residence or citizenship, they can open bank accounts and conduct business easier. And finally, I would say many people are thinking about diversifying their assets right now. I mean, I don't actually handle this, um, but many of my clients are asking me about how do they open bank accounts in Switzerland or Singapore or other parts of the world. They don't necessarily want to hold all their assets in the United States. Investment migration can be part of that strategy because in many cases you are moving money to another country, either in the form of real estate or in terms of stock purchase or investing in venture capital or private equity. So it can kind of be a bonus for your diversification of asset strategy that many people are thinking about right now. Next.
Now, Judi, when
Yes.
you talk about having a plan B, and I think many people are probably familiar with the term dual citizenship. Can you talk about how dual citizenship is kind of a misnomer in a way, that there really is no limit to the number of
Yes.
places you can be a citizen?
Yes. The United States does not limit the number of citizenships that you can hold. I have clients that have a portfolio of 3 or 4. So that is not a restriction the US places. The one thing you do have to be careful about is you don't want to obtain citizenship to another country that may not recognize it with the United States. There aren't many, but surprisingly, Spain does not recognize dual citizenship with the US. So if you were going to have a route to citizenship there, not via descent, because there is a waiver for descent at this stage, although that's going to be expiring. But if you were to obtain Spanish citizenship for Spain, they could presumably ask you to renounce your US citizenship. Austria, for example, says, yes, you can have Austria as an additional citizenship, but once you get Austria, you are not permitted to have further citizenships unless you are granted permission. So for clients that do a program with us in order to gain Austrian citizenship, and they say, yeah, they also want to have a Caribbean citizenship, we make sure we get that before they get Austrian. So you may wonder, do I have to renounce my citizenship if I get another? And I guess in following to what I just explained, no, that is not the case. The US allows you to have multiple citizenships. In fact, I've never actually had a client that was using our services because they intended to renounce. About 1% of our clients are renouncing. Of course, if you're planning to renounce, you do need our services because you can't be stateless. You need to have some sort of a citizenship before you renounce. But renouncing is a very complicated endeavor. And I think my colleagues here on the panel might be addressing that in a few minutes. It can also be quite costly for someone of high net worth. But my clients are not even thinking about a relocation at this point. Um, of all the clients that I have dealt with, I have had literally 3 of them that are spending more than 6 months a year in another country. These were families that wanted to give their kids opportunities to have a global experience, and one family is moving to Spain, another family has moved to Portugal. I have another family that's planning on moving to Italy. But that's an extremely small percentage of clients that I work with. Most of my clients are not planning on relocating. In fact, most of them want to stay under 6 months because that usually is the magic number for which you become a tax resident. Next slide.
And both the issues of renouncing citizenship and becoming a tax resident are issues that our colleague David Shapiro will address in his section.
Great. So I'm going to speak at an incredibly high level about taxes because I'm not licensed to give tax advice. But it is something that people ask a lot about. And the first thing I would say is that tax planning is part of this strategy for clients that intend to become a tax resident elsewhere, and that we work in conjunction with Saul Ewing and with local tax professionals in the countries where the client could potentially intend to become a tax resident, meaning staying over 183 days in most cases, to make sure that clients fully understand what that could mean for them. But just by becoming a resident of another country or by becoming a citizen of another country, other than the US, you do not necessarily become a tax resident of that country. So, yes, if you were to say become a Greek resident by purchasing real estate and you turn it into an investment property and you generate rental income, yes, you will pay tax for that. But in terms of the fears of tax on worldwide wealth, that really only comes into play if you become a tax resident. Typically, you have to live there for 183 days. There are some exceptions. Switzerland is 90 days. Some other countries may say if you are spending more time in our country, such as France, than you are elsewhere, or if it's the center of your economic interests, that can trigger tax. So it's something that has to be looked at, but it also doesn't necessarily have to be something that is feared. Next. Oh, we discussed this. Next. I do want to talk briefly about citizenship by ancestry because we are a land of immigrants and some people are able to obtain citizenship by virtue of their bloodline. I personally am actually getting German citizenship for myself and my kids. Both Germany and Austria passed laws in the recent past that said if your family fled due to Nazi persecution, you and all future generations are entitled to citizenship. But many other countries also have rules, laws that will grant citizenship by ancestry as well. It's a specialized area, and Henley has relationships with experts, attorneys in several countries: Austria, Germany, Portugal, Spain, Ireland, Italy, Romania, and Poland, where we can connect you and they can assess whether you have a path to obtain citizenship via that route. One common question with citizenship by ancestry is if I am entitled to it, but my spouse is not, what does that mean? Well, it means that your spouse is not getting citizenship. However, in the EU, they do have a freedom of movement law, which states that if you are married to an EU citizen, you are able to live in Europe as long as you are with them, which means that if they die or you get divorced, you no longer have that right. But my husband doesn't have to worry that when I get my German passport, I'm going to be leaving him behind. Next. So here's a top level overview of the most popular programs that Henley Partners supports. Some of them are going to appeal to people living in other parts of the world. So I've never done actually, I'm just doing my first Thailand, but it's unusual for an American to be doing Thailand. So again, the programs are going to appeal based on where you live. What I'd like to do on the next slide, please, is just dive into what are the programs that most Americans are considering right now. The first is Caribbean citizenship. And you might be wondering, like, why would I want a Caribbean passport? But first of all, it's very cheap. You can get citizenship for your entire family for either making a donation in about 250,000 or investing in real estate for somewhere around 300,000, which can be sold in 5 or 7 years. And it's, as I described, the difference between residence and citizenship. This is a guaranteed right. This is an additional mobility option that you'll have. And the Caribbean passports are actually quite strong right now. You can enter Europe with them. You can enter the UK, about 150 countries. Now, will you always have visa-free access to Europe? That's a big question because the EU is getting more concerned about programs that grant access to Europe. And so any of my clients that are getting Caribbean passports, I have to warn them that I just don't know whether at some point the EU may take away visa-free access. So it shouldn't be your primary motivator. But look, many people are buying second homes in Florida. Maybe they buy it in Antigua and they get citizenship for the entire family. When I talk about family, who's included? So usually it's parents and it's children, but there can be rules based on the country about the ages of the children. For example, Antigua says your children up to age 30, whether they are financially dependent you or not, can be on your application. So you can have parents and maybe 3 adult children up to the age of 30 all getting citizenship, and they can add their spouses, as well as their children. The real estate angle for the Caribbean is also very interesting, especially for multi-generational families, because the amount that's required per family is around $300,000. So I have families that will buy a villa and we subdivide it into shares, 300,000 for the grandparents, and then 3 adult children and their full families, meaning spouse and multiple kids themselves, each take a $300,000 share for 1.2 million. They all get citizenship, and in 5 years they can sell the villa if they don't want it. And they don't have to use the villa. It can be put into a rental pool with full property management services, and it's just an investment property, but they've all gotten citizenship. So Caribbean. The next area would be Europe, and we have,
So Judy, just to
yeah.
interrupt for a second, when you talk about those programs that require or include the purchase of real estate, and you were just going through that with an example with Antigua, how involved does Henley get in uh, helping find the property or facilitating the purchase of the property abroad? What exactly, how far does your role go? What role do you play exactly?
So for the most part in the Caribbean programs, you need to purchase something that is permitted by the Citizenship by Investment Unit. So it's not like you're just going out with a realtor and finding a property and saying, I spent 300,000, now give me the citizenship. So there are dedicated projects that most of our clients are investing in. If you go to like the website for some of these countries, they'll probably list like 20 or 25 projects that will qualify. But at our firm, we do a very high level of due diligence on these projects, and so there's only a handful of them that we would even introduce our clients to, because we want to introduce them to projects that are going to get built. These often are spec projects. The villas will take 12 months to be built in some cases, and we don't want our clients investing in something where it's never going to actually happen. We want to invest in something that we have significant confidence that they can take advantage of the exit strategy in 5 or 7 years. But yes, we facilitate that. We are full service A to Z. If there is any element of the program regarding how the money is invested, we will guide the clients to the appropriate tools to enable them to make educated decisions and fulfill that part of it. In Europe, we have two strategies. We have residence and we have citizenship. I'm going to start talking about residence with the Portugal Golden Visa, which many people have probably heard of because it's one of the most popular programs that's out there. One of the reasons it's popular is because although it's a residence program, it has a reasonable path to citizenship. Reasonable in that you don't have to spend a ton of time in Portugal to ultimately be able to apply for citizenship. It is not a quick path, though. So we can get our clients submitted very quickly for the Portugal Golden Visa. It usually takes around 3 months. They do need to make an investment. They have two choices, either a 250,000 euro gift into an arts or cultural organization, or a 500,000 euro investment into venture capital or private equity. Similar to your question about real estate and how we help, we are not financial advisors, but what we will do is we will provide them with a list of maybe 10 or 12 funds that most of our clients have used successfully to apply for the Portugal Golden Visa. The clients will say these 3 or 4 are of interest to me, and then we will connect them and their financial advisors, if they'd like, with the fund managers so that they can get a full overview of the fund, prospectus, past performance, and make an educated decision. But we will facilitate the subscription for them into that fund once they have made that decision on their own. So we submit them in about 3 months. And unfortunately, due to the popularity of the program and probably the bureaucracy of Portugal, our clients are waiting over 3 years for the Portugal Golden Visa to be issued. So for people wanting a quick plan B, this is not it. Or you do it in conjunction with something like a Caribbean, which is very fast. You can get St. Kitts in 4 to 6 months, or a Costa Rica where you can get a residence very quickly. Once the visa is issued in Portugal, you then have added responsibilities. You have to start visiting Portugal 14 days every 2 years. You must maintain your investment. You must renew the visa after 2 years, which is done in person, and then in another 3 years if citizenship has not been granted. And you must pass an elementary level Portuguese language test or take 150 hours of Portuguese language school. At that point, you can apply for citizenship. That's year 5. And then that is taking about 20 to 26 months to be approved. So it's a path to an EU passport, which I told you is really powerful because once you have that, not only can you live in Portugal, but you can live anywhere in the European Union. Other residence programs that are also of interest are Italy. You can invest 250,000 in a startup or 500,000 in Italian stock. You can gain residence very quickly. The main applicant usually somewhere around 30 to 60 days. But you also must have an address in Italy, which can come slightly thereafter the approval. So you have to lease or purchase. Greece has a residence program. As I mentioned earlier, you can invest in real estate in either a refurbished property at 250,000 euros, or if you want to purchase more of a home that you intend to live in as opposed to an investment property, which is what those 250 properties probably are, you can invest either 400,000 in the smaller areas in Greece, or 800,000 in the larger areas like Athens, Mykonos. Greece has an interesting carve out that parents can be on an adult child's application. So again, when I'm talking to families and they have kids and they maybe have parents or grandparents, these are the kind of things I think about before I make recommendations, because if you need to do multiple applications, it can get expensive. So you want to maybe sometimes look at strategies for programs that are going to help you use fewer applications to get to your end result. If you needed 2 or 3 applications in Greece and you were buying in a 400,000 euro level, you could buy 400 times the number of applications you need. So a home for 800,000 and 2 applications are covered, or 1.2 million and 3 applications are covered. And again, it could be used for personal use or investment use. They do allow you to rent it out, but not for short-term rentals. And Malta has a residence program whereby you have the ability to live unlimited in Malta. Now you'll notice there are 4 asterisks next to Malta. And that is because had I done this webinar 2 weeks ago, I would have also told you that Malta has a citizenship program. However, there was some very unexpected news last week where the High Court of the European Union declared that Malta's program was illegal. And so currently, the Malta Citizenship Program is not accepting any applicants, and we're waiting to find out what's going to happen here. Why did this happen? Well, as I alluded to earlier, some countries are sensitive right now to migration, and Europe in particular, the EU in particular, is not happy about programs that grant citizenship to people who then have the ability to live anywhere in the European Union. And they had been suing Malta for the past 4 years to try and close this program. But to be honest, the decision was very unexpected because the Advocate General of the European Union had found in Malta's favor just in October in a very legal opinion stating that the EU does not have a right to tell a country what laws it makes. And if it allows this precedent of telling Malta that they cannot have this law, what else can the EU tell another country? Can they tell them how to tax? Can they tell them other things? Nonetheless, this is what has happened. So news about the future of the Malta program is to be continued.
And just for background, because I don't know that everyone knows what the Malta program was, it was very similar, as I understood it, to what Trump is proposing inbound to the United States. Is about $5 million of a payment to the Malta government, and you would effectively get Maltese citizenship in about 48 hours. You had to
Okay, a little different.
I mean, it was pretty quick. Right?
Okay.
Or you had to go there for about 48 hours and pick up
Okay,
your
kind of. So I'll just very quickly talk about the program that doesn't exist anymore at the moment. There were 3 components to it. One was a large financial gift. It's 750,000 euros, so less than 5 million. And that's for the main applicant, and then 50,000 for each qualifying dependent. Malta also required you to hold real estate for 6.5 years, either purchase or rental, to show a tie to the country. And it did require you to make 3 trips to Malta, 2 days to get residence, 21 days over the next 12 months, and then to come for an oath. But given even that amount of ties or financial commitment, the EU says that was not a strong enough tie for people to make to be granted citizenship within a period of about 14 to 16 months. So that's where we're at right now. It's good that Eric mentioned the gold card because many people are very curious since Trump says he's already sold 1,000 of them. But that program does not exist yet. Fake news. We'll see whether it actually comes to fruition or not. I'm just going to very quickly talk about a couple other programs that are really interesting, and then I'll turn it over to David. One is New Zealand, which has just made some really interesting changes to its program on April 1st to make it much more attractive to investors. And it fits really nicely into this diversification of asset strategy that I was talking about as being a driver, because essentially they require you to move 5 million New Zealand dollars or 10 million New Zealand dollars, depending upon how active you want to invest that money, to New Zealand for a certain period of time. 5 million New Zealand 3 weeks ago was 2.8 million USD. I think it's not as good. I think it might be 2.9 million now. If you choose the 5 million New Zealand route, the 2.9 million USD, you have to invest it in private equity, venture capital, or private credit. And we will connect our clients with a top independent financial advisory firm to design the portfolio that the client is happy with. The main applicant has to spend 21 days in New Zealand over that 3-year period. Everyone else in the family has to enter New Zealand and exit in the first 12 months, but they don't have any required time. It literally could be 1 day. And then at 3 years, you can liquidate your investment and you have permanent residency for life, which is pretty powerful. So you could never come back to New Zealand, but you and your children would have the right to live there at any time in the rest of your lifetime. Now, for children, they do need to be under the age of 25 at the point of approval. So when I talk to families where the kids are over 25, it does become much more expensive in terms of how much liquidity you have to move to New Zealand. But it's a great option for people that have that kind of money. People are making percentages of return, about 8 or 9% right now, most of the investors, and getting this permanent residency, which does not give you a passport. It's not citizenship. If you want to be a citizen, you have to live in New Zealand for 5 years, but it gets you almost everything else that a citizen has. You can live there unlimited. You have access to healthcare. You can work there. It is English speaking. Your kids could have careers there. Unlike, the Caribbean, you're not necessarily going to want to have your kids living there for the next 20 years and having careers there. And other than competing for the Olympics for New Zealand, running for parliament, or getting a top level security job, you have the rights of citizen. You can actually vote as a permanent resident. So I think New Zealand's really interesting, and I'm getting a lot of interest in it. Costa Rica, I'm getting some interest in. Again, a residence program. So, you'd have to feel like maybe I want a plan B. I don't want to spend a lot of money. I want something that I know would be available to me very quickly, and I could see myself living in Costa Rica if I had to. You only have to demonstrate that you have $2,500 in passive income. So a certified CPA in Costa Rica will review an investment statement showing that you have interest or dividend income, or that you have rental income of that amount. There's a workaround as well. You could deposit $60,000 in a bank and put it in $2,500 a month shares, or you could invest in real estate at $150,000 per family application. It starts out as a temporary residence, which you hold for 3 years. You have to renew it after year 2. Once you are a permanent resident after year 3, you could work for a company in Costa Rica, but while a temporary resident, you could only work remotely. Once you are approved, you do have to pay $300 a month into Social Security, which gives you access to healthcare as well as a pension. And it takes about a year to be approved, but Costa Rica says once you've submitted, if you choose, you can live unlimited in Costa Rica until your approval comes through. You do have to go to Costa Rica to apply. There's 1-day visit. And then once you are approved, you have to visit Costa Rica 1 day a year. Australia, I'm going to talk about very briefly, because I swore to David I wouldn't talk this long, but I can look at the clock and I'm talking longer than I thought. Has a global talent visa. There are more countries that are coming up with global talent visas because they want to attract talent. So if you are under the age of 55 and you have contributed substantially in areas that are of interest to the Australian government, supply chain, healthcare, technology, research and development, even entertainment, you do not have to make any kind of investment. They will grant you a visa that is good for 5 years, and you can include your family in this visa. Now, to renew it, you have to contribute to the Australian society, and that involves spending time there and also doing things. So, I mean, you really shouldn't pursue it necessarily as a plan B unless you're prepared to not get it renewed after 5 years. Portugal also has a talent visa, which can speed up your process a little bit, but will require you to engage in a mentorship or relationship with a university. But that's a very interesting area to look at. And I think I'll end it there. I can talk about future programs that people want to pop in the chat if they are interested about other things that I didn't cover.
One more question, Judi, before we let you go and switch to David. Can you talk a little bit about how Henley gets compensated for its services?
Sure.
The arrangement works?
Good question. So we charge a flat fee based on the country as well as the number of applicants. We only charge once we can be of legitimate service. So, I talk to lots of clients. There's no fee for consultation with me. So if you legitimately want to learn more, That's what I'm here for. Some clients decide rather quickly. Some clients I talk to for a year. But once you do decide, we would onboard you, which involves a due diligence. We do a background check. We need to see legitimate source of funds demonstrating that you have the money to pay for the program. You would sign our agreement, and then you'd pay a retainer, which usually is around $10,000 or 10,000 euros. The balance of our fee is due at submission. And just to give you an idea of what our fees are, for the Caribbean, 30,000 for a single applicant, 40,000 for a family of 2 to 4, 50,000 for a family of more than 4. For Portugal, Greece, most European programs, 25,000 euros for a single, 30,000 for a family of 2 to 4, 35,000 for a family of more than 4. There are some outliers, Austria being one of them, and I didn't really go into a lot of detail, but with the situation as it exists in Malta right now, there is a path to a passport for people that make extraordinary contributions in Austria, but we're talking 4 million, and our fee is higher for that one. But it's an incredibly interesting program, so if you can afford it, we should definitely discuss it. We are A to Z. So if there is legal consultation needed, a tax consultation is included, bank account openings, introducing you to the real estate projects, introducing you to the financial managers if there's a financial investment that's involved, as well as all of the collection of the personal documentation. I kind of make the analogy that we're like your accountant. Like you can't just call your accountant and say, okay, do my taxes this year. You have to give them information. So yes, you're going to have to give us your birth certificate. We're going to tell you how to get it apostilled, which is a certain kind of certification. We're going to connect you with a third-party translation service if it needs to be translated. But you are going to have to get the documentation. You are going to have your own medical test if a medical test is required. We are going to pre-fill the forms as best we can, but we're not going to know the names of your siblings, which might be required. So it's a collaborative effort, but we try to make it as easy and seamless as possible.
Great. Thank you. Thank you very much, Judi. That was terrific. All right, let me turn it over next to my colleague, David Shapiro, who's going to talk about the tax implications should you become a resident of one of these foreign jurisdictions.
All right, thanks, Eric. Can we let's jump to the next slide and we'll dive right in. All right, so what I'm going to talk about today is for people who are looking at getting alternate citizenship or additional residence, but not looking to give up US citizenship. I will note now that if you're thinking about renouncing, we do have a tax on expatriation, essentially a mark-to-market, as if you sold all of your assets, which can be a really bad result if you're treated for US purposes as if you sold all your assets, but you then still have to pay tax on those assets in whatever your new country is. So not only that, there are also some estate tax implications where if you leave things to people who are back in the US, they can be subject to additional tax on those assets because you're no longer within the estate tax net. So that's a separate conversation. It's a very serious conversation. It's one we do deal with from time to time. We do have people expatriating, though more commonly what we see are people who have green cards in the US, giving up those green cards and dealing with the mark-to-market for that, but not so much US citizens giving up citizenship. So if you are a US citizen, what does that mean? The number one thing it means is you are subject to worldwide taxation by the US. The US imposes tax on all of your income from whatever source derived, from wherever in the world that might be. Now, you do get a credit against your US tax liability for foreign income taxes paid, and that can include, I'm sure a number of you have foreign investments where there might be some foreign withholding tax on dividends, and that would count as an income tax. But in general, the tax has to look kind of like a US income tax. It has to provide deductions. It has to be sort of a net income-based tax. If you don't get that, you may be able to take a deduction for other taxes. So your foreign property taxes and things like that. If you own real estate overseas, there are things that still can affect your US liability and help drive down your US tax liability to account for the foreign taxes you're paying. Right, let's go to the next slide. Now, if you do get residence somewhere else, Judi mentioned, and we'll come back to the question of whether you're a tax resident in that other country in a little bit. But if you are a tax resident, you have to watch out. Like a lot of the countries that have fairly popular alternate residence by reason of, for instance, getting EU access, also can carry with them a fairly high tax bill. I mean, you look at the top Portuguese tax rate, that's 53%, including social contributions, and Italy and Greece are in the 40s. Now, Italy and Greece do have this special lump sum tax regime that you could use as an alternate. A lot of people from non-US countries love this because they become Italian or Greek residents and they're not paying tax anywhere else. They're just paying 100,000 or 200,000 euro of tax. Doesn't work for us Americans. You pay that 100,000 of tax, and then you also pay US tax on top of it. And by the way, that lump sum probably does not constitute an income tax or a qualifying surrogate to income tax, so you don't get a credit for that. Still, when you look at the overall math, that might be advantageous if you are looking at becoming a resident of one of these other countries. All right, can we go to the next slide, please? So Judi alluded to the 183-day rule that you see in a lot of places, but that's not everywhere. Like Switzerland has the shorter rule. And so you can, depending on different countries' rules, be resident in 2 or 3 different countries. Like your nightmare scenario would be, let's say you spend 184, 185 days in Italy, but you are in Switzerland for 3.5 months, but you're also a US citizen. Under those rules, all 3 countries would say you're a tax resident of that country. So how do you sort that out? You take advantage of tax treaties. And US tax treaties are pretty strong, and they typically have, for individuals, very clear tiebreakers where you can say, well, okay, I may have spent 100 days in Switzerland, but I don't have a permanent home in Switzerland. Or my center of vital interest, like the rest of my family lives in the US. My job is primarily in the US. There's a whole litany of factors that you go through. And the ultimate tiebreaker typically is citizenship, where if you go through all the other tests and you're still treated as a resident of both, only where you're a citizen are you a resident. It is possible in rare cases to be treated as resident of both countries under the treaty, and then you can go and seek special relief from what's called competent authorities, which is basically the treasury departments of the 2 countries negotiating to say that which one gets the taxing rights. I will note that if you're asserting that you're a US tax resident and needing to use the treaty, the other country may require IRS certification, and good luck on that. It used to be that it took maybe 5 or 6 months. Now we don't know how long it's going to take. Staffs have been cut. You may be putting in an application and waiting 8, 9 months to actually get your certification. The US is unusual in that you could self-certify. Most other countries, if you're claiming treaty benefits, you have to provide certification as to your eligibility, and they may impose a tax, and then you have to go for a refund after you finally get your certification. But again, talk to tax advisors if you're thinking about this. Okay, so Judi talked about how there are investment-based residents in a number of countries. Can we go to the next slide, please? So when you're investing, if it's a fund type investment, private equity fund, venture fund, for example, you have to watch out about what that might be. There's this, we U.S. tax lawyers, one of our four-letter words is PFIC, Passive Foreign Investment Company. And one of the things you need to watch out for when you're looking for suitable investments is the particular investment going to be a PFIC, or because of the way it's structured under local law? And if it is, are they doing the things to help you out? Now, why is that important? Let's take a couple of minutes and talk, starting with the next slide, please. Okay, so you have to start with, is a foreign entity treated as a corporation for US tax purposes? Generally speaking, you've got a corporation if no owner has unlimited liability. So there are different standards of what that might mean, but it's always worth checking. And generally speaking, even certain foreign partnerships, because of the way that liability might be limited on the general partner, if they're seeking US investment, will make a protective election. You can make an election as to tax classification for many, but not all foreign entities. They'll make a protective election to be treated as a partnership for US purposes, or they may otherwise provide certifications that, yes, in fact, they're a partnership, and you do your diligence and get comfortable. But if you're investing in a corporation, the corporation, if it's a fund, is probably going to flunk both the asset and the income test. If more than 75% of its gross income is passive income, dividends, interest, rents, royalties, or capital gains from the sale of those types of assets, or more than 50% of the asset basis on a weighted average is in those types of assets, you have yourself a PFIC. So that covers basically any foreign mutual fund. So if that's one of the investment paths you're looking at where you can invest in local portfolios and you're doing it through mutual funds will always lose. Venture funds and private equity funds can be PFICs or they can be pass-through. But with venture funds, you even have to worry about, well, what are they investing in? Because early stage companies can be PFICs because cash is treated as a bad asset. There's a very limited startup exception that you can use, but it's very limited. So you need to make sure when you're looking at investments, when you're looking at where you're going in, that you're dealing with advisors and you're dealing with fund managers that are paying attention to this stuff. And the reason that's important is because of the way PFICs are taxed. Very quickly, next slide, please.
So David, I gather from what you're saying, PFICs are bad and investing in something that's taxed as a partnership is okay. That's kind of...
Can be okay, right. So, and we'll come, yeah. So, the bottom line with a PFIC is that if you invest in a PFIC, you're taxed at tax rates depending on the length of hold of your investment, where your effective tax rate on the investment is going to be somewhere between 50 and 100%. So and potentially over 100% if it's a really long hold because of the way that the interest charges work. It's really ugly. And the way that you get around that is on the next slide, please. You have to make sure that even if you are investing in something that is a PFIC, you can make a tax election that treats it effectively like a partnership, provided that you get the information that's required to do those tax returns, effectively getting information that allows you to create a nominal K1. And you have to get covenants from the company, from the fund, whatever, to do that. And if you're investing in a fund, you want the fund to be looking down to the things it's investing in, either to test for PFIC or to do the reporting that's necessary or get the reporting that's necessary. So this is all about, when you're looking at this, make sure that your advisors are picking things or steering you to things where the folks are looking to accommodate and facilitate US investment. And as Judi mentioned, this is a relatively recent development that Americans are looking so aggressively for alternate citizenship or residency. So historically, a lot of the investment programs and the people doing them weren't structured so well for this and weren't thinking about it. But as we're getting more mature and more US investment, you're seeing more of that and more funds paying attention. Okay, can we flip to the next slide, please? We were talking a little bit about real estate. And you might buy a villa somewhere. Well, one thing you need to think about, just like you think about it in the US, is how am I going to buy it? Am I creating an entity to hold it? Am I acquiring an entity? There are some jurisdictions like France where people virtually never actually sell the dirt. They're always selling companies that own the real estate. And oh, by the way, those companies are in the form that is always treated as a corporation for US purposes. So if you're holding it with the intent to generate investment income, you're going to have to do some of the PFEC planning yourself for the real estate. Real estate is one of those things also where even though most of our treaties limit the right of a country to tax non-tax residents, real estate is always the exception. And you should fully expect that you're paying local tax on that real estate. You're paying local tax when you sell that real estate. You're paying local tax when you sell a company that controls that real estate, unless you do planning to deal with that, to manage some of the taxes under local law. And as to real estate, Jeryll will be talking in a minute about estate tax and related things. This is one of those things. If you own real estate in a foreign country, you need to be aware of what the foreign country's inheritance rules are, because that real estate is a local country asset and subject to that country's rules. And your US will and US estate planning may or may not be fully effective. Of course, if you're doing all of this, sorry, the next slide, please. You need to be mindful of compliance issues. You have to deal with local compliance and potentially, how does that local compliance translate into US compliance? Sometimes you have different tax years, which requires you to do kind of funky slicing and dicing to get to your US reporting. And it takes time as well. This is one of those administrative things you need to be aware of. I have worked with a number of clients with foreign investments for years. Not a single one of them files their US tax return before late September at the earliest, because it takes that long to pull everything together from the foreign taxes. So just something that you need to be mindful of. You need to have accountants who are bilingual or trilingual in terms of not just language requirements, but actually the tax laws, and at least have teams where they can understand what the tax law of another country is and how it translates into the US. Different assets may be subject to different regimes. One of the big ones we see a lot these days is cryptocurrency, where the US and a lot of other countries all have different ideas about what the moment of tax is, how it's taxed, when, and all of those things have to be synchronized, not just for the compliance piece, but then you think about, well, how and when do I actually engage in a transaction, and how do I do that transaction to minimize the mismatches? And the last thing I want to mention, speaking of mismatches, and this will be a great segue to Jeryll, is trusts. Can we flip to the last of my slides, please? Okay, so trusts, that's easy for us to think about in common law countries. Most common law countries have trust concepts very similar to the US. For instance, I know a lot of people around the world love New Zealand, which Judi mentioned earlier, because New Zealand has a very good and robust trust regime. But if you're talking about civil law countries, they trusts simply do not compute, and they cannot handle the idea of the trust being its own taxpayer. So from that perspective, I have a client, for example, that's resident outside the US in a civil law country where we wanted to, for estate planning purposes, establish some trusts. And we concluded the way to do it was to do that as a defective grantor trust, where it's a completed gift for US estate tax purposes, but income tax purposes, our client is still the US person paying tax. And we had to make sure that the trust was structured in a way that Spain would also say they look to find which individual is the taxpayer, that during his lifetime, he is still the individual paying tax for Spanish purposes. So we have a connect where he's going to pay the tax for Spain and then get a credit for that tax in the US. Not every country works the same way. Unlikely that most people are thinking about India as their additional citizenship country, but India has a particular clubbing regime where they will impose tax on the person perceived as the moneymaker to get it at the highest possible rate. But the US might not respect that and therefore you have a mismatch again between who's paying tax in the US and who's paying tax in India. So you have to watch out for these kinds of mismatches. You also have to think about it from a planning perspective. A lot of these countries, civil law countries, use something called foundations, which can look more like corporations for the US. So when you're setting up a foundation, you need to make sure if you're trying to do US style planning and US rules applying, you want the foundation to behave, have legal documents that work in a way where we can say, yes, that's a trust for US purposes, and here's how it works. So with that as the background, I'm going to hand off to Jeryll to talk more about estate planning and related matters.
Jeryll, if you don't mind, I'd like to interrupt for 1 second because we did have a question come in from one of our attendees. It's probably a question directed to Judi, but David might have some input here as well. And the attendee asks, thinking about creating a company and hiring myself as an employee in order to expedite the ability to live abroad in a new country. Is this something you've heard of people doing? Is this something you can't do, and why?
I mean, my preliminary thoughts are maybe a digital nomad visa would just be a faster way to be able to work in another country without establishing a corporation and trying to hire yourself. Presumably, this person could work remotely and doesn't actually need the company infrastructure. But this would have to be looked at like depending upon the country. Like, for example, in the UK, a company needs like a sponsor license in order to hire someone. And then there's regulations in terms of like if you're hired under the sponsor license, how many hours you have to work a week. I think it has to be at least 35 hours a week. So it's actually not something I specialize in, but it would be the kind of thing if this person knew what country they wanted to go to, I could make an introduction for them to a local attorney to explore ways for them to go. But there's not an easy answer to that from
There
my
is
perspective.
another reason, from a tax perspective, there may be a reason to do that, which is maybe not for the individual directly, but sometimes I'll see this where maybe you have an individual or there's a family that owns a company where somebody's going to be moving overseas and doing local country operations or doing some services for the overall corporate group and wanting to avoid permanent establishment type issues and creating tax for one company in another jurisdiction, you create new subsidiary in new country, move the employment to the new country, and use that in some cases as part of the visa sponsorship process. But you're also using that to sort of isolate local country liability where that company is charging the other group members or charging sister company and paying a portion of that on to the individual, retaining a portion as profit subject to local tax and trying to contain local country tax exposure. So I've seen that. All right, I think then, Jeryll, love to hear about estate plan.
Thank you. Good afternoon, everybody. I'm going to talk a little bit about estate planning and what you should be doing pre-planning if you are thinking of relocating or investing in a foreign country. What is estate planning? Estate planning is the formal process for designating the persons or charities that will receive and manage your assets upon your death or incapacity. It generally consists of a will, which is the most common device to dispose of your assets. As David mentioned, trusts, which are recognized in common law countries, but generally not recognized in civil law countries. What is a trust? It is an agreement between the owner of the property and the person they designate as the trustee, pursuant to which the owner transfers their assets to the trustee, who holds the assets for the benefit of the beneficiaries according to the terms of the agreement between the trustee and the settlor. There can be a lifetime trust, revocable trust, which can be changed by the owner, settlor, and also testamentary trusts, which take effect upon the death of the settlor, and irrevocable trusts, which are not subject to change or modification. There are also beneficiary designations for assets that pass by contract, such as insurance, IRAs, retirement plans, annuities. And also, you need a durable power of attorney for management of property. In addition, your estate planning documents should also include a power of attorney for making healthcare decisions. Next slide, please. If you're going to be multi-jurisdictional, it is important to have a comprehensive estate plan. Why is that important? You want to ensure that regardless of where your assets are located, where you die, where your beneficiaries are located, or where you reside, that the individuals and charities you want to receive your assets upon your death do receive your assets, notwithstanding those other factors. Next slide, please. It's important to plan because each jurisdiction has its own rules about how assets are transferred on death, as well as transfer taxes, in addition to income taxes, as David Shapiro discussed, the rights of the surviving spouse, as well as family members, the probate process and administration, and, as we've been discussing, the treatment of trusts. In order to ensure that you have a proper, comprehensive cross-border estate plan, one of the first things that you need to do, besides consulting with Henley Partners about your desired locations, possible locations, is to put together a team of advisors, including legal, tax, and investment advisors who understand the relevant estate succession, generation skipping, transfer, and estate tax laws in each relevant country that may be involved in the distribution and management of your property. One of the things that you should do after putting together your team is to put together an inventory of your assets and their location. Assets are anything that you own of value, and it includes your tangible assets, physical assets, jewelry, house, cars, art, collections, your financial assets, cash, cash equivalents, investments, CDs, bank accounts, etc., intangible assets, intellectual property, copyrights, right of publicity, brands, and your digital assets, which are non-physical items stored electronically. It's important for you to continuously update your inventory list and the location of the assets so that you can make sure that you make any adjustments to your planning that are necessary. Next slide, please. As mentioned, the location of your, can you turn to the next slide, please? The location of your assets is important because it will determine the applicable law. It will determine the tax treatment as well as the manner in which you can devise your assets. In some cases, the situs of your assets is easy. For your tangible assets, it's where they are physically located. Real property, tangible personal property, where the real property or tangible personal property is located. Your intangible assets are a bit more complex. That depends upon the nature of the property, the relevant jurisdiction. Each country has its own rules and interpretation of situs rules. Your advisors will be able to help you to navigate these rules and determine what location what the situs is for the applicable property. You will need to go over your inventory with your advisor to determine that. You should start with a foundation for your U.S. assets. Can you go back to the previous slide, please? The most common way, as I mentioned earlier, to dispose of your assets is a will. You should have a will that covers your assets located in the U.S. Most people in the U.S. also use trusts. A trust makes it easy to transition between your death and the succession of your property and avoid probate. However, as we have mentioned, trusts do not always work in foreign countries. But you can have a trust for the assets that are located in the U.S. You should also have a power of attorney for management of your U.S. assets should you become incapacitated or unavailable due to your being physically located in another country. A durable power of attorney for management of property is a document in which you designate a person, your agent, to manage your assets if you are not capable of doing it or you are not available. You can give the agent the power to pay bills, handle bank transactions, sell assets, deal with creditors, complete and file your tax returns. It should be somebody that you trust. And you can specify in the power of attorney the powers that you are giving the agent, as well as the instructions to the agent with respect to your assets. The agent under a power of attorney is a fiduciary and must act in your best interest. You will also need to have a special power of attorney for that applicable to wherever you are residing or where you own assets. You should also have a power of attorney for healthcare. A power of attorney for healthcare is a document by which you designate a person to make healthcare decisions for you should you become incapacitated. Again, the laws that regulate healthcare differ in each country. You will need a healthcare directive for the state that you reside in the United States, as well as the relevant country where you will be residing. You can include in that document the kind of medical care you wish to receive, including end-of-life decisions, disposition of your remains, etc. You do need to make sure, if you are having multiple documents in multiple different jurisdictions, that they do not conflict with each other and that they are consistent, even if your agent in the particular jurisdiction is different than the agent in your US. You should also make sure that your primary healthcare provider has a copy of your healthcare directive, and you may also want to provide the copies of that document to your family members. As I mentioned, you need to be very careful when you have multiple documents for different jurisdictions that they don't conflict with each other. One of the things that can happen, for example, is in these documents, there typically is a statement that says this document revokes all prior documents. You want to make sure that you are careful with that language, because then you will be negating whatever document you have done before for a particular jurisdiction. You should make sure that your beneficiary designations for insurance, IRAs, annuities, retirement plans are clear, that they reflect your wishes, and that they will work cross-border. You may also want to consider making funeral and burial arrangements. You may have strong feelings about where you want to be buried, and you may want your body moved back to the United States if you pass away in another country. You may also prefer cremation. You should consider making arrangements ahead of time and prepaying the funeral and burial expense, as well as making arrangements for the transportation of your remains. It is important to understand the rules in the relevant jurisdiction for moving your remains. You should also have digital asset protection strategies and make sure that your attorney-in-fact, your personal representative, your successors have instructions for access to access your digital assets, and you should have a plan for incapacity. For example, some platforms allow you to set triggers to automatically transfer digital assets to trust companies if they detect a certain period of inactivity. I can't emphasize enough how important it is for you to do a regular review of these documents and your plan so that you can adjust for life-changing events such as children, grandchildren, deaths, residence changes, and changes in your assets. You should also explore the possibility of minimizing estate and gift taxes, including looking at 529 plans, irrevocable trusts, lifetime gifting, etc. Again, you're going to need to consider the laws in the relevant jurisdiction in order to make sure that you are complying with them and not running afoul or causing any negative tax treatment. Next asset, please. Next slide, please. You should understand, and again, your team should be able to help you with this, understand the succession law in the relevant jurisdiction. The probate process is different depending on the jurisdiction. Some jurisdictions have extensive, expensive probate processes, and some have none. You need to look at whether your trust will be recognized in that jurisdiction, and you need to know whether your will be valid. You need to know whether the jurisdiction where you will own property has forced heirship, which I'm going to talk about in a few minutes. And you need to also understand whether if you have a prenuptial agreement, that's going to be recognized in the jurisdiction that you might be investing in or owning property in. For example, Greece does not recognize prenuptial agreements. They are void as against public policy. Your team should also explore the estate taxes in the relevant jurisdictions as well as the treaties. I'm going to talk for a few minutes about U.S. estate and gift tax. The United States imposes a tax on the transfer of assets during lifetime and on death. This tax is imposed on the transferor. The United States is one of only 2 countries where estate taxes are based on citizenship. If you are a U.S. citizen, the transfer tax applies to your worldwide assets, regardless of where you are residing at the time of your death or where the assets are located. In addition, there are states in the United States that also have transfer taxes that may apply. The United States does allow for an exemption from the estate and gift tax. In 2025, that exemption amount is $13,990,000. That means that you can transfer during your lifetime or on your death a total of $13,990,000 without incurring a transfer tax. A married couple can transfer twice that amount. There is also an annual gift tax exclusion in 2025. That amount is $19,000. As well, you can make direct payments for tuition and medical expenses without incurring a transfer tax. The tax regime that allows for these exemptions is set to sunset on January 1st, 2026. And unless the legislature enacts a new tax bill or extends that tax regime, the exemption amount is estimated to go down to approximately $7 million. If you have assets over that amount, the exemption amount, the current tax rate, transfer tax rate, ranges between 34% to 40% of the assets above that exemption, 40% being the applicable rate for all assets over $1 million. In addition, the United States imposes a generation skipping transfer tax if your assets go to grandchildren or more remote beneficiaries. Many foreign countries also impose a transfer tax on the basis of residence or physical location of the assets. While their taxes may apply only to the assets located there, remember that the United States taxes your worldwide assets. Therefore, it's important to do proper planning so that you can minimize the effect of double taxation. And in order to do that, you need to understand the laws, the applicable laws, and the exclusions, as well as the tax treaties. They can be very important. Tax treaties control where you are considered a domiciliary, the physical location or situs of your assets, what happens if both countries claim situs, that is, tie-breaking rules, and the tax treatment or availability of credits. The United States has estate and/or gift tax treaties with 15 other countries, including the UK, Australia, France, Germany, Japan, and Denmark. The United States has an estate tax treaty only with Canada, Finland, Greece, Ireland, Italy, South Africa, and the Netherlands. Treaties are very important because they may determine a number of the different ways that the rules affect you. If there is no treaty, the United States may provide some relief in the form of what's called foreign tax credits. That is, you may get a credit for the tax that is payable in another country. However, the applicability or availability of those foreign tax credits could be changed by presidential proclamation. It could be changed, for example, if there's a lack of reciprocity with the other foreign country. Next slide, please. It's important to understand the succession law that's applicable in the country where you either will be residing or investing or purchasing assets. David mentioned common law versus civil law. In common law countries, which is what the United States is, and the UK, Australia, New Zealand, one of your property rights, very important property rights, is the ability to leave your assets to whoever you want to. Civil law countries are different. There is something called a forced heirship rule in civil law countries. That means that you are not free to leave a certain percentage of your assets to anyone. Rather, a certain percentage of the assets must go to your spouse and or children. And this goes all the way back to public policy reasons that your dependents, spouse and children, should not become burdens on the country and that they should be provided for. You also need to understand the treatment of spouses, the character of property, the laws that are applicable, whether a prenuptial agreement is going to be valid. As I mentioned, Greece does not recognize prenuptial agreements. You also need to understand whether the jurisdiction allows you to opt out of their succession law, and you may be able to do that under the EU succession regulation. So you need to understand whether you can do that and how to do that, and make sure your documents properly do elect the law that you want to be applicable. Next slide, please. We discussed previously about planning for your US assets. You also should plan for the assets that are located in other countries. As mentioned, a will is the most common form to plan for the disposition of your assets on your death. The validity of the will is going to depend on the applicable jurisdiction. Generally, a will is going to be valid if the decedent is competent, the will is in writing, it's witnessed by the requisite number of witnesses, expresses testamentary intention, is dated, and describes the assets to be distributed. There are two conventions that authorize a foreign country to recognize a US will: the Washington Convention and the Hague Convention. One of the other things that you need to decide is whether you're going to have a single will to cover all your assets or a situs will, an individual will specific for the country where your property is located. Some advisors suggest that you have a multi-jurisdictional will. However, it may be more advisable to have a situs will for a number of reasons, including the designation of executor may be restricted by the situs. Some countries will require that the executor be a resident of that country. As well, if you select an executor in that country, they will understand the language, they will understand how to navigate the laws, and so it may be advisable to have a US will for your US assets and a situs will to cover the assets in the particular relevant country. Again, you need to make sure that the multiple wills, do not contradict each other with respect to the dispositive terms and do not somehow revoke each other. Many countries have forced heirship rules, which restrict your ability, as I mentioned, to leave your assets to whoever you want. A few examples are Italy, which depends on how many children you have and whether there is a spouse. If you have a spouse and more than one child, 3/4 of your assets located in Italy must go to the spouse and direct descendants. Now, the foreign country cannot dictate, does not have jurisdiction over your assets that are not located in that country. However, the foreign country may impose a rule that requires that the way your assets outside that country are disposed of are taken into account for determining the amount of your assets in that country that must go to the statutory heirs. Italy, in addition, has a clawback provision for lifetime gifts. In Portugal, 50 to 60% of your assets must be allocated to the spouse and descendants. There's no inheritance tax there, but there is a stamp duty. In France, there's the 1, 2, 3 rule. One child gets one portion of the estate, one half of the estate. If you have 2 children, it's 2/3, and if you have 3 or more, it's 3/4. In Antigua, spouse and children cannot be disinherited and have a right to maintenance. Antigua does recognize trusts. Switzerland recently changed its forced inheritance rule, and a half of the estate must go to children and spouse. BVI does not have an inheritance tax or forced heirship, but the country of domicile, if you have assets in a BVI trust, may determine whether the forced heirship rules of that country are applicable. The Isle of Man has no inheritance tax, and there's no forced heirship, but there is a land registry fee on the transfer of real estate. Canada does not have a forced heirship. However, dependents and spouses may have claims for support. Australia and New Zealand are probably the most comparable to the United States. They recognize trusts, and there is no heirship. Costa Rica does have forced heirship. There's no inheritance tax. And in Costa Rica, as well as in France and other countries, many expats will hold their property in corporations. Although if you do that, which bypasses the probate process, because those countries don't recognize trust. However, if you do that, as David mentioned, you have to consider the implication of the US income tax as well as the foreign countries' tax rules. Next slide, please. If you have minors residing in a foreign country, it is important to plan for what's going to happen to your minors if something happens to you. Your US will and trust and estate planning documents may name a US person as a guardian, but the jurisdiction where your children are residing may require that in order for the children to move back to the United States, they will need to have a legally recognized guardian in that country, and there may be a court proceeding required. So you need to find out whether you need to do any special planning for your minor children. Next slide, please. Finally, important, you should do an annual review of your assets, their location, and your documents to ensure that things go the way you want them to and that no adjustments are needed for lifetime changes. Thank you. Happy to answer any questions.
So, Jeryll, one question that occurs to me is, and I know you talked about the fact that all these jurisdictions are different and there's different rules, but in terms of the big picture, when you're talking about your inheritance and having a will, and the factors that apply to whether the foreign country law is going to apply or US law is going to apply, is it really that you're a resident of that foreign country? Is it that you die in that foreign country? Is it that the property is located in that foreign country? What is the primary factor in terms of when you have to worry about having a will in a foreign country?
Well, definitely where the asset is located.
Where the
is
asset
going
is.
to be subject to that jurisdiction.
Okay.
But if you reside in one of these countries, they may also have rules that apply to determine those factors. But for sure, the physical location of the assets, and again, physical location may be easy for some assets, like real estate, but it may be more complicated for intangible assets. And the treaties, the specific laws, will have to be examined to determine the rules that apply.
Okay. And we also had one of our attendees ask a question specifically about the Isle of Man. You mentioned there was no inheritance tax there. And the question is, if an American citizen has dual citizenship, US and the Isle of Man, how does that citizen avoid having its assets not subject to US estate tax? Is that possible, or would they have to renounce to do that?
I think they would have to renounce. What do you think, David?
Yeah, no, they'd have to renounce, and in order to renounce, they would have to deal with the exit tax. So I'm not sure that's necessary. Well, depending on the situation, that may not be crazy. Depending on what sort of the asset mix is, that might work. The exit tax might be less painful than the estate tax, but that's a relatively rare situation in my experience.
Right. Great. Well, amazingly enough, we're finishing almost exactly on time at 90 minutes. So I want to thank our panelists today, Judi, David, Jeryll. Thank you very much. And on behalf of Saul Ewing and Henley Partners, I'd like to thank all of our attendees for their participation in today's discussions. If we did not get to anyone's questions, which I think we got to all of them, but if we did not, and there's some additional questions submitted, we'll do our best to send you a response by email. And in the meantime, feel free to reach out to any of our presenters with questions. You have the information on the slide here about how to get in touch with us. In addition, when we send out the post presentation email, it will have contact information for all of us, and you can reach out to any of us with further questions. Thanks again for attending, and we look forward to hearing from you in the future.